I'll be speaking first. Oh, there you go. That was one of the things I was to warn you all about. And Sarah Phillimore, also member of the family team, will be speaking second. I've been asked just to do a couple of housekeeping points before we start. First of all, as you have all just been told by the automated American lady, we are being recorded. Secondly, you will see that there is a Q&A and a chat function available. If possible, can you put questions in the Q&A, although our marketing team will be keeping an eye on the chat function as well, and if needs be, can copy and paste any questions into the Q&A for us. And then finally, when you come to leave the webinar, there will be a survey to complete. And if you feel able to complete the survey with feedback, that would be very much appreciated. Okay, without further ado, I will start. And as you know from the advertising, I am speaking about the decision of Mrs. Justice Roberts in the Somerset case. Now, I'm aiming to relatively swiftly cover 7 different subtopics to deal with the case. The first of all is, why does compliance with the rules matter? Secondly, what are the requirements? And then a bit of a scamper through what we would expect to see in a compliant child permanence report, a compliant adoption medical and/or health summary, and I appreciate the health summary is part of the CPR, we'll come back to that shortly, and then a compliant agency decision maker, or ADM, decision. And then I will look briefly at the Somerset decision itself and think about what you should do if you discover a mistake with any of those aspects whilst you're still in proceedings, so before your placement order has been made. And then secondly, which of course is more strictly what Somerset itself dealt with, what you should do if you discover a mistake after proceedings have concluded. So, going back to the top of that list, why does compliance with the rules matter? I mean, I'll put to one side the rather obvious point that rules are generally intended to be obeyed, but more fundamentally in this particular context, these rules matter, of course, because we need to ensure that ADMs and courts take the right decisions for the child or children that they are concerned with. Secondly, we need to ensure that if a court does agree that a child or children should be placed for adoption, then any future carers of that child or children need to have accurate information about them so that they can provide the right care, and also so that they can take the right decision as to whether they think they're appropriate carers for that child. And then finally, because these reports, in the context of the CPR, of course, are reports that the child themselves may access in the future, it ensures that the child should have in that document an accurate record of their own history. Now, in terms of the requirements and what the rules are, there are 2 main elements that I want to look at: the CPR, the Child Permanence Report, and the ADM decision. In terms of the CPR, as I've bullet pointed in the notes, that is governed by the Adoption Agency's Rules 2005 as amended. And if you go to the government website and click on legislation website and click on most recent, you will get an amended version of the rules. They are up to date at present on the site. And regulations 15, 17 and Schedule 1 are where you will find the detail. And in terms of the CPR, the detail of what should be in the CPR is in parts 1 and 3, and the detail of what should be in an adoption medical is in part 2 of Schedule 1. I've also set out some of the main authorities in the notes, in particular Re B 2008 and Re S 2014. Now, re-B, it was quite interesting to reread as I prepared for this evening's talk, because Lord Justice Wall said in re-B that widespread dissemination of this court's analysis of what occurred in this case should be sufficient to prevent repetition. It was perhaps kind of Mrs. Justice Roberts in the Somerset decision not to point out that those words in re-B didn't appear to have achieved their aims. Now, of course, in re-B, the court was dealing with a slightly different factual scenario. In re-B, some key expert reports hadn't been provided or summarised in sufficient detail, such that the decision of what was then an adoption panel prior to the ADM decision hadn't had before it all of the relevant information. The recorder, dealing with the final hearing, when he became aware of those difficulties, tried, through hearing evidence, to decide if, in fact, despite the panel and the ADM not having had that information, they had nonetheless come to the right decision. So effectively tried to right the wrongs of the panel and the ADM. But Lord Justice Wall was very clear that that is not a route which is open to the court, and said that it must follow that if the decision of the adoption agency panel is flawed in any material respect, then the decision maker cannot properly consider the recommendation and thus cannot be satisfied, in accordance with the process laid down by Parliament, that the child in question should be placed for adoption. And the Court of Appeal confirmed that the proceedings should have been adjourned so that a fresh decision could be taken by the panel and the ADM, and then the case could be reconsidered by the court. So that was the relatively clear framework that we had set down in re-B. Turning now to look briefly at the contents of a child permanence report. Now that's set out in Regulation 17. There's obviously quite a lot of background information about the child's family history and the child's life experience. And it's fair to say that that generally seems to be of a pretty reasonable quality in the reports that one sees. The bits where people seem to come unstuck, to me at least, seem to be the following. The summary written by the agency medical advisor of the state of the child's health, his health history, and any need for healthcare which might arise in the future. An assessment of the child's emotional or behavioural development and related needs, and the analysis of future care options and why adoption is the preferred option. If we start with the health summary. Now, in Somerset, Mrs. Justice Roberts was plain that the failure to include the separate health summary, quite specifically separate from the adoption medical, was a breach of the regulations. And the reason for that becomes clear if you delve into the detail of the schedule to the 2005 regulations. Because in the adoption medical report, you are not required to include detail about future health needs, but that is intended to be covered by the health summary. And so, although at first blush, it sounds like there's effectively an overlap, certainly to me, and I'm in relatively good company with Mrs. Justice Roberts, it seems that there isn't that full overlap. Now, of course, the agency medical advisor who conducts the adoption medical is likely to be very well placed to write a health summary in pretty short order, but you do need to have both. And note that the rules are clear that the health summary must be prepared by the agency medical advisor. I say that because the case that I finished yesterday nearly came unstuck because the child permanence report had the health summary prepared by the social worker summarising her telephone call to the agency medical advisor. Now, I make it very plain, the social worker, of course, was not doing anything deliberate, but the fact remains that the rules state it should be prepared by the advisor rather than the author of the report. We were able, thankfully, to find a workaround because we had a little bit of extra time to play with. We were able to get the agency medical advisor to write the summary, to send it to the ADM, for the ADM to confirm that that didn't alter their decision, and for the final hearing to then conclude on time. But the devil is in the detail, and if in doubt, double check whether your report is compliant. The other point just to highlight about the role of the agency medical advisor is that certainly, again, on my interpretation of the statutory guidance, it seems that the medical advisor should be a doctor. I say that because, again, I am aware, at least anecdotally, that not all adoption medicals are currently being performed by doctors. Now, in terms of the adoption medical, again, I have set out in the notes a summary of the regulations which govern the adoption medical, and that's Regulation 15. And the headline really comes from Regulation 15.2b, which requires either that an examination takes place and there is a report summarising that examination, and the details of what that report should deal with are set out in the schedule, or there has to be advice that an examination and report is unnecessary. Now, the regulations don't state what I'm about to suggest would be good practice, but it seems to me relatively obvious and clear good practice that if you do decide to go down the route of there being no examination and report, that the rationale for that is recorded very clearly in writing and probably forming part of the health summary as well in the CPR, so that it's clear to everyone. I mean, you can see and think of situations where it might be unnecessary. Let's say you have a child with a very, very uncomplicated medical history who has had a child looked after medical that was pretty extensive very shortly beforehand, conducted by your agency medical advisor. In those circumstances, yes, you can see that you might not need a medical, but it needs to be set out clearly and your decision making recorded, just to ensure that there are no difficulties. And obviously, if you're representing a parent or child or children, you will need to check that and take a decision yourself as to whether you think that was the right route, and if not, to raise your concerns with the local authority promptly to avoid any delays. Now, moving on to another area linked quite a lot of the time to the health summary and the adoption medical is summarising the child's needs. As I set out in the notes, the reasons, it seems, at least to me, why it matters that that is included in the child permanence report and that it's recorded accurately is partly, as we've already discussed, to inform future carers, but also because one of the things, of course, that an ADM is looking at, and the court, is whether this child is suitable for adoption. So do they have the sorts of needs which can be met by adopters, or are their needs sufficiently complex and unusual that they may need specialist residential care or a very specialist foster placement, for instance? And that needs to be set out with some care in your CPR to ensure that you've summarised the child's needs accurately, and that any decisions about, and I know it's a horrible term, adoptability, are valid decisions which aren't susceptible to challenge. Turning then to an area which, again, as I said at the outset, certainly in my experience seems to be an area of challenge, which is the analysis of future care options. I appreciate that ReBS is a 2013 case, and the best part of 9 years on, it now feels like rather old law. but it remains very good law, and it remains law which the courts expect local authorities to comply with. And it has to be an analysis which is meaningful, looks at the realistic options, and sets out genuinely all of the pros and cons of each of those options. I've summarised in the notes that, of course, when considering adoption as a realistic option, the 2002 welfare checklist will have to be borne in mind. And that's very important, of course, when thinking about contact as part of the picture, and whether you're going to be recommending, or whether there is a recommendation if you're for a parent or guardian, about any contact for the birth family post-adoption, or if there can't be contact post-adoption, what the implications of that are for the child. Of course, that usually becomes particularly relevant when you have one of those cases where one child or more than one child will be potentially placed for adoption and other children won't. In terms of the ADM's decision, next area to look at, I've summarised the guidance from Hofstetter and London Borough of Barnet. Now, it is a judicial review, and it is in a slightly different context, because actually Mrs. Hofstetter was applying to be approved as an adopter, an adoptive parent, and information came to light during the process, late in the process, that Mrs. Hofstetter had not disclosed, which caused the agency assessing her, London Borough of Barnet, quite some concern, and her approval was rescinded. And Mrs. Hofstetter complained about the way in which that process had happened and whether it had been fair. And the administrative court set out the guidance for agency decision makers. And whilst that guidance, as I say, was in the context of ADMs considering prospective adopters, the Court of Appeal in SF, and I've set the reference out there again in the notes, specifically approved the guidance in Hofstetter. And that is that the decision should, the record of the decision should list the material which they've taken into account, should identify the key arguments either way, should ask if there's been a panel, whether they agree with the approach of the panel. Obviously, when the sorts of situations that we're talking about today, we no longer have these decisions taken by a panel in the first instance and then considered by the ADM. It goes straight to the ADM. But of course, in this context, the ADM would be asking themselves whether they agree with the recommendations in the Child Permanence report, and ask themselves whether they're satisfied about the fairness. They would have to consider whether there's any additional information which has been obtained in Hofstetter's language that was not before the panel. In our language, that would be information which wasn't available at the time of the CPR, and should identify the reasons given for the recommendation and whether they do or don't agree with those. So again, does the ADM agree with what is set out in the CPR? And then finally, setting out their reasons. And the other thing, and I've realised that I've probably put a bullet point in the wrong place in the notes, which I apologise for, is that please, please, please ensure, if you are for a local authority, that the reasoning is not effectively this child is very young and therefore it has to be adoption. Case law is very clear that that is not good law. It has to be an analysis of why for this particular child adoption is the right thing. If you are for a parent or a guardian and the analysis in the ADM record of decision is simply that this is a young child and so it should be adoption, then your ears should be pricking up. You might want the ADM to come and give evidence. You might want to alert the local authority to these deficiencies, because that is not necessarily a compliant ADM decision. Now, I'm sorry that background scamper has taken about 20 minutes, but it's important to have that scene set before we look at the Somerset decision. Now, what was the ratio of the Somerset decision. This is on the last page of your notes. So I'm actually going to look at this very briefly before we jump back to what on earth do you do if you discover that there have been mistakes in your case. First of all, bullet point A, that a breach of the regulations doesn't automatically invalidate a placement order, and the court retains the ability to look at the nature of the breach and determine whether the essential quality of decision-making has been materially undermined. That the court is not correcting or rectifying the errors. I think it's important to pause there because perhaps not pause there, sorry. If we look at bullet point E, which is the key question, is whether there was sufficient information available to the ADM at the time of the decision so that they had available sufficient information, including medical information, so as to make a fully informed decision. I say and highlight that because in several of the Somerset cases cohort, and although the Somerset Cohort Children, actually Mrs. Justice Roberts did not say that any of those placement orders should be set aside. In each of those cases, there was quite a lot of relevant information available to the ADM, which enabled Mrs. Justice Roberts to find that it wasn't necessarily needed for each of those children that an adoption medical took place. But of course, that is a fact-specific exercise in each case that's dealt with and reviewed. And what you need to be very careful to avoid is looking at information acquired after the ADM's decision, which is new information, which might be said to substantiate the decision the ADM took, but wasn't available to the ADM at the time. That information cannot cure defects, and that's summarised in bullet point C. It is not permissible to look to information obtained subsequent to the decision to provide retrospective legality. And I've already spoken about bullet point F there, that it is a breach of Regulation 17 for the Child Permanence Report to not contain a summary from the agency medical advisor. And then, of course, bullet point G is the one which is almost of most day-to-day relevance once you've gone through those preceding 6 bullet points, but where the substance of the decision is not vitiated by material error or understanding and not undermined by the procedural irregularities which the breaches of Regulations 15 and 17 represented. The placement order was lawfully made. So with that brief summary of the Somerset decision in mind, there are 2 scenarios which are likely to occur. The first, fairly similar to what I was dealing with tail end of last week and start of this week, is that you discover a mistake and you are mid-proceedings. You have 2 options, as I've set out in the notes. First is that, and this is primarily with a local authority hat on, that you attempt to proceed on the basis that not all mistakes invalidate an ADM decision. Some might say that is, unless your mistake is really very small and narrow in nature, some might say that's probably a bit of a risky strategy, because of course, if the court disagrees with your analysis of the nature and gravity of the mistake, you are going to be sent away to get your house in order and for the ADM to reconsider. And depending on when your mistake comes to light, that may ultimately result in you losing more time than by going with option 2 to withdraw the application, rectify your mistakes, go back to the ADM, and then reissue your placement application. I mean, I don't want to be thought to be saying that there are no cases where you could press on, but it strikes me that if your mistakes are anything other than very small, that it is likely to be prudent, subject to anything which comes out in the President's decision later this month, it's likely to be prudent on the current state of the law to withdraw, go back to ADM and reissue. Then our second scenario, help, I've discovered a mistake post-proceedings. This, of course, is very much on all fours with the Somerset decision, and Mrs. Justice Roberts in the Somerset decision suggests that the remedy is issuing a Part 18 claim. But as I set out in the notes, there is currently pending before the President a hearing to look at this very issue. And I've put the title of the note, the guidance issued just over a month ago by the President. And in paragraph 3 of that guidance, the President states that in early March, he will consider legal argument as to the best and most proportionate means by which cases involving this kind of non-compliance can be addressed. This will include consideration of an approach that does not require a judicial determination in relation to each individual child. A judgment will follow in which guidance will be given as to the approach to be taken by local authorities, children's guardians, and the courts. Now, at the moment, without knowing what arguments are being made, it is quite difficult, it has to be said, trying to think about this with an administrative law hat on, thinking back to my law degree all those years ago. It's quite difficult to envisage a non-judicial approach, but there are undoubtedly finer legal minds than mine looking at that issue at the moment. And so the current advice is actually, in general terms, rather than issuing that Part 18 claim, to sit tight. However, the guidance does go on to highlight 3 specific categories of case where you can and should still issue. Now, they're examples, but they are the most obvious examples. The first are where, in the view of the local authority or adoption agency, there is a risk that an adoptive placement with which the children or child have been matched will be lost if that can't be progressed further. Secondly, that there's a risk of losing a placement for which they're about to be matched. And thirdly, that the child or children are already in an adoptive placement, which may break down if a pending adoption application is delayed. I mean, I may be teaching people to suck eggs in my last minute or two, but of course, the difficulty with not getting the court's approval to progressing matching or placing or pressing on with an adoption application if the decision-making process has been deficient is that, and again, I don't hold myself out as an administrative lawyer, but it seems to me that the decision of Mrs. Justice Roberts indicates that placement orders made when there has not been full compliance with the 2005 regulations are voidable rather than void. Now, the blessing and curse of a voidable order is that it might be just fine. The court might decide that actually the order should still stand, but it might not be fine. And if it is not fine and that placement order is set aside or held to be invalid, then any actions taken under that placement order, which flowed from its legality, become, putting it kindly, exceptionally problematic. And so that is why, if you are in one of those urgent situations, you will still need to issue a Part 18 application. It seems to me that it would need to be supported by a statement summarising why this case is particularly urgent and how it falls within the President's guidelines. Other than that, yes, the advice is to sit tight. So I'm sorry that has been a bit of a whistle-stop tour. It is surprising how fast half an hour goes when you're speaking, even if to a slightly disconcertingly blank screen. I can see that there are 80 of you sat there. It just feels slightly lonely. I can't see anything in the Q&A or the chat. And so I will hand over to Sarah, who is going to give you a short summary about dolls. Oh, thank you very much. You are listening.
Hello, I think my notes are going to be circulated or have already been circulated, so don't worry about references and so forth. I do, however, want to start off just by reminding you of a case which I didn't include in the notes and I should have done, because it's a really useful case of why everything went horribly wrong in a case involving the deprivation of liberty of a 13-year-old. And it's a really useful case because the judge takes the time to set out in some detail the applicable law about deprivation of liberty, and also touches on the inherent jurisdiction, what it is, how it came into being. So that's, if you're feeling a little unsure or unfamiliar about these concepts, and it's a really good case to start with. And that's AB, a child, human rights, and that was a judgment handed down on the 1st of April last year. And the reference is 2021 EWFC B100. So very much recommend that as a case where it all went horribly wrong. So I'm going to give the counterpoint to what Julia was talking about and discuss when it's actually really okay to break the law, to act in defiance of the relevant regulations, and when the court is going to allow this, and what can we learn from this, and what are the distinct issues between those two scenarios. And the key area, of course, is deprivation of liberty. Was when children have to be deprived of their liberty, that generally means they cannot safely be with family or foster carers. So we have to look for somewhere else for them to live. And there are three main types of accommodation. There's secure accommodation, which, as we all know, a secure children's home designed and developed as such and approved by the Secretary of State for such use. So this is accommodation with a custodial complexion. It's going to have locked doors and windows, perimeter fences, high quality digital CCTV. And as we're also all aware, the big problem with secure accommodation is there just isn't enough of it for the children who need it. So you can't find a place in secure accommodation. You can then look to a children's home. That's defined as a place that provides care and accommodation wholly or mainly for children, and it excludes hospitals and most schools. Under the Care Standards Act 2000 and accompanying regulations, children's homes must be registered. It's potentially a criminal offence under Section 11 of the Care Standards Act to run an unregistered children's home. If you haven't got secure accommodation or a children's home, you're then looking at unregulated placements. So this, for example, could be a caravan or an outward bound centre. And I know that certainly courts have expressed serious doubts that such unregulated placements could ever be suitable to be used to deprive a child of their liberty. So we're going back to section 22C6D of the Children Act. You've got a child you need to place, you're a local authority. You've got to find a placement that's the most appropriate. Section 22D confirms that a local authority can make arrangements to place a child in an appropriate placement when it's necessary and required as a matter of urgency. But in September 2021, the situation got more complicated because Regulation 27A of the Care Planning, Placement and Case Review, brackets England, Regulations 2010 came into force. So under Regulation 27A, a local authority can only place a child under 16 in accommodation in England in accordance with arrangements under Section 22C6D of the Children Act, when the accommodation is one of the types specified by the regulation. And those types are a care home, Now that's defined by section 105 of the Children Act. It's the same definition as in the Care Standards Act. So an establishment is a care home if it provides accommodation and nursing/personal care for persons who are or have been ill, or have had a mental disorder, who are disabled or infirm, and who are or who have been dependent on drugs. Then a hospital is permitted, defined by section 275 of the National Health Service Act 2006, a residential family centre, as defined in section 4.2 of the Care Standards Act, a school, as defined by section 4 of the Education Act, or a holiday scheme for disabled children, as defined in regulation 2.1 of the Residential Holiday Schemes for Disabled Children, England Regulations 2013. So you're now told that in order to stay within the law, a child under 16, if you haven't got a foster family or a children's home, these are the only places where you can put a child in order to ask that their liberty is deprived. But what do we do if we don't have access to any of these places? And it seems to be a constant and increasing difficulty in so many cases that there just isn't anywhere for a child who desperately needs to be contained and to be kept safe, because the child is in enormous distress and often self-harming and suffering really quite serious mental and emotional trauma. So what do we do? Well, the inherent jurisdiction comes into play. Now, we know that it is possible for the High Court to authorise, under its inherent jurisdiction, the deprivation of liberty of a child under the age of 16, even where the placement is prohibited by the terms of the care planning, placement and case review regulations. So just first, a quick aside about what the inherent jurisdiction actually is. In theory, it's that limitless power of the High Court to make decisions if there's an apparent gap in the statute law. But in practice, you've got to be really clear about why you are invoking the inherent jurisdiction. And I think the case I cited at the beginning makes that really clear. This is a hugely serious issue. Depriving children of their liberty is extremely serious, and so too is invoking the inherent jurisdiction. There is certainly nothing merely technical about this. And we've got real difficulties and tensions in relying on the inherent jurisdiction in the area of depriving children of their liberty, because we are purporting to undermine a statutory or regulatory framework which exists for entirely essential reasons, to make sure that accommodation provided for children in care is fit for purpose and the children's rights are protected. So as a general rule, the more an area of law is controlled by statute and regulations, the more extreme the circumstances have got to be to justify the use of the inherent jurisdiction. But we can see that, unlike the situation discussed by Julia that pertains to the adoption regulations, the court will allow you to breach these regulations, and to do so in a potentially criminal way if you are relying on imperative necessity. So let's unpick that a bit further. The two cases of interest and relevance here are, I think, the Supreme Court decision in July of last year, and that was on appeal from the Court of Appeal in Re T, a Child Secure Accommodation from 2018, and then the case of Tameside MBC and L, Unavailability of Regulated Therapeutic Placement, 2021 EWHC 1814. I can sum it up. If there's absolutely no alternative and the child or someone else is likely to come to grave harm if the court does not act, see paragraph 145 of the Supreme Court decision, then breach of the regulations is permitted. Otherwise, there could be a potential breach of Article 2 of the European Convention, and Article 2, of course, protects the right to life. But this mustn't be seen as the court authorising a criminal act. Practice guidance issued by the President of the Family Division in 2019 made it clear that if a child is placed in an unregistered children's home, then steps have to be taken immediately to secure registration and to keep the court informed of the registration process, which the court will oversee. Now, if registration is then refused and the home continues to operate, that's when it seems that the risk of criminal prosecution could bite. But let's just have a look in a little more detail about what the Supreme Court was doing in Re T. It was asked to consider the following issues. In circumstances where insufficient places are available in registered secure children's homes, is the exercise of the inherent jurisdiction to authorise a child's placement in unregistered secure accommodation lawful? If it is, what's the legal test that the court should apply when determining whether to exercise the inherent jurisdiction? And is the child's consent to this confinement of any relevance when determining whether or not to exercise the inherent jurisdiction? And I'll just stop there and say that there was clear confusion in the submissions to the Supreme Court about the distinction between unregistered and unregulated, which I hope I've made clear by just the brief synopsis of the different kinds of placement. So the Supreme Court dismissed the appeal and said, yes, you can use the inherent jurisdiction, but we've got really grave concerns about using it to fill gaps in the child protection system which exist due to lack of resources. The child's consent or lack of it did not determine the decision about whether a deprivation of liberty was permissible. If you're going to put a child in unregistered or unregulated accommodation, it must be a temporary solution only if no other alternative is available and it reflects a scandalous lack of provision. So if we look at the Supreme Court and the judgment in Tameside, I think we can draw up a list of important factors which you've got to bear in mind when you're asking for permission to break the law. The fact that the court has allowed you to commit a criminal act, such as running an unregistered children's home, may not allow you to escape prosecution for that act, but I think it would be a very persuasive argument that it wouldn't be in the public interest to prosecute. From what I can see of those cases involving breaches of the Care Standards Act, it seems that it's only deliberate and contemptuous breaches of regulations that are most likely to attract attention. So I think a good starting point when you're faced with one of these cases is be really clear, what are we dealing with? Is this proposed placement a children's home? If so, if it's not registered, we've got to immediately apply for registration. Is it one of the establishments set out in Regulation 27A for a child under 16? If so, brilliant, no problem. You can justify it by Section 22C6D and 22D of the Children Act. The big problems, though, are if you don't have a children's home and you don't have a Regulation 27A placement, you're then going to have to focus very much on what is urgent and what is necessary for the court to authorise a placement outside the regulations. So if you're in that situation, I think a list of bullet points that I've drawn together from the two authorities, I think usefully can be set out as these. First of all, do conditions of imperative necessity exist? Are you looking here at a choice between placing the child or the child risking death or serious harm? Imperative necessity has got to be seen in the context of a best interest analysis. And it's just not appropriate, the courts have said, to try to define what may constitute imperative considerations of necessity. Each case has got to be decided on its own facts. So you're not going to get much help from the published case law. The court's got to ensure the rigorous application of the terms of the President's guidance of 2019, if this is potentially something you could register as a children's home. And just to ask the obvious questions. Has the provider of this placement confirmed it can meet the child's needs? What steps have the local authority taken to assure itself that the premises and that those who work there can give safe and suitable care? What is the proposed regime at this placement? What are the justifications you're putting before the court to why this proposed regime is necessary and proportionate? And of course, importantly, the child's views. What is the child saying about this proposed regime? So I think it's really clear, hopefully, why we are in this position where we've just been told by the courts that breach of the adoption regulations is absolutely unacceptable and must never be allowed to happen again. Whereas we're breaching the regulations with regard to placing children deprived of their liberty, it seems on a daily basis. We're allowed to do this, we're in this mess, because local authorities are in a very difficult position, which are not of its own making. And I think we can see this really clearly from the judicial comments. For example, Lord Stevens says at paragraph 178 of the Supreme Court judgment, "I agree with Lady Black that recourse to the inherent jurisdiction in the fact of this scandalous lack of provision should be a temporary measure. I add my name to the list of judges who have called attention to this issue, which is a scandal containing all the ingredients for a tragedy." And this was echoed by the judge in the Tameside case. However, I can observe that in the experience of this court, the prohibition on placing children under the age of 16 in unregulated accommodation contained in the amended statutory regime is not coming into force on the 9th of September 2021 in the context of local authorities choosing to utilise such placements for vulnerable children in great need. Rather, it is coming into force in the context of local authorities having no choice but to employ such unregulated provision due to the well-recognised acute lack of appropriate provision. So certainly at the moment, the judges are very well aware and sympathetic of why this is happening. What does worry me, however, is I can't see that the resources issue improving anytime soon. And this is almost going to become common practice, isn't it? That we are simply resigned to the fact that there is no designated secure accommodation for children who need it. And we start looking around for bespoke placements in all sorts of unsuitable environments. So I think what we've all got to do is be very clear. Although the court have certainly authorised acting unlawfully when it's that or leaving a child to die or suffer serious harm, I don't think we can ever become complacent about just how serious it is when we're asking permission from the court to break the law. And so hopefully people will bear that in mind, and hopefully this situation will improve, because I think I echo what is said by Lord Stevens. It's quite incredible that there hasn't been some appalling tragedy arising out of this, and hopefully that there won't be. I trust that's been a clear romp through why we are allowed to break the law when it comes to depriving children of their liberty, but you won't be allowed to break the law when it comes to abiding by regulations concerning placement orders. So I'm just having a quick look in the chat function, and I can just see general praise for Julia, well done, and no particular questions. So unless anybody has any particular questions, then that certainly is the end of my presentation. Well, if there aren't any particular questions, then I think probably we can call that a night. And if anyone hasn't got the documents, then please do let us know. Oh, and I've also been asked to just remind you that there is a survey about how you felt that the use or the interest of this seminar was. So please do fill it in, because we do want to make these events something that's useful for people, not just something that you suffer through, but something that we can actually all engage with and share our learning and experiences. So do please tell us what you think went well or what you think we could improve on. So just, we might have a question from
Yes,
Rice.
I have just seen a very
over to
specific
you
question about Regulation 16. I mean, I think the bottom line, the short answer is that all parts of the regulations are mandatory unless and until the President tells us otherwise in the decision that we expect later this month. And so I would assume that, yes, you have to thinking about answering, that you have to comply with all of the regulations, and yes, therefore you have to get as much information as you can. The caveat I would put on regulation 16, having now reopened my copy of the regulations, is that of course there is the caveat on both sub 1 and sub 2 that it is so far as is reasonably practicable. And just to translate regulation 16, that is the regulation which relates to information about the child's family, about the health of the children's parents, natural parents, and their brothers and sisters, whether full or half blood. Now, of course, you do have the caveat in there, so far as is reasonably practicable. I think what I would therefore suggest is that if you are having great difficulty getting information, but you have made relatively strenuous efforts, that as long as you summarise in the Child Permanence report the efforts that you made to get that information, that to me would seem to be compliance with the rules. You get a little bit more slack with regulation 16 than with parts of the other regulations. I mean, for me in my copy, regulation 16 runs over onto a page where regulation 17 is, and of course regulation 17 in contrast begins with the adoption agency must prepare a written report, the Child's Permanence report, which shall include, and then sets out in mandatory terms what that report has to contain. So I hope that is helpful. Just check that, oh, it was just a thank you was the other thing in the Q&A. Thank you very much. Thank you. I think in that case, that deals with everything. And just wait a minute or two more in case there are any other thank yous, but I can see the numbers dropping off as everyone dashes away to get their pancakes. I can hear that mine are starting to be cooked now for me, which is very pleasing. And if there are no other questions, in that case, we will let you all go home, and thank you ever so much for being here. Good night.